Today's date is April 7th, and this is the second argument that we're going to hear today. It's also involves attorneys Paprocki and Remke. It's the state of Ohio versus Ryan Yatson, case number 20CA011658. Same panel, Judge Hensel, Judge Callahan, and I. We've read the briefs and are prepared to proceed. If you are, before you get started though, would you like to reserve any time for rebuttal, Attorney Remke?
I would like to reserve 5 minutes.
5 minutes. All right. And I'll let you know as you get close. You may proceed.
Great. Again, may it please the court, Giovanna Bremke on behalf of Mr. Yatson. This is a case that has a lot, so ask me questions because I don't know that I'll get to it all. But Mr. Yatson was indicted in 2016 on 5 separate counts, mainly felonious assault, improper handling, and discharge of a weapon into a habitation. He proceeded to a jury trial in 2019, so about 3 years ago. Exactly, it was May of 2019. He was found not guilty on count 1, but the jury was hung on the remaining counts and specifications. And specifically, those transcripts are in the record. And specifically, you'll see that they're hung on complicity, and that's important later on. He proceeded to a second trial, ironically, March of 2020, right as the pandemic is hitting, about a week before that. So the trial, throughout the course of the trial, like I said, there's a lot here. There's 8 separate requests for a mistrial. I cite those in my brief where the attorney asked for a mistrial. The trial ended 3 days after the state of emergency was declared for COVID-19, and eventually my client was convicted, but not sentenced until July of 2020. And after several months, the trial ended again in March, but he was not sentenced until July. This is about an incident that occurred in September of 2016. There were shots fired into, I'll use the initials, CR's home. There's 2 CRs here, but into CR's home, and his father and sister, who's also a CR, were in the home. And the sister CR was struck by one of those bullets. The defense in this case repeatedly argued that if Yatson made any mistakes that night, it was not locking up his guns. There was a neighbor, basically CR and Yatson were, on different streets, but close in proximity. The backyard sort of butt up. And there was a neighbor down the street who saw the vehicle, who is suspected to have shot in the home. It was a shooting from a vehicle, and was familiar with Yatson. He had done work on her home or with her husband on the home, and it testified that it wasn't him that was in the vehicle. The first assignment of error deals with jury misconduct. There's a juror number 8, who I'm going to describe as sort of the bad egg juror, who repeatedly there's issues with. So the biggest thing is she brings in a complicity definition from a crossword puzzle dictionary. And this judge allows note-taking during the course of the jury trial. So when he's collecting the notes after the conviction, he's collecting notes and sees that there's a different color page in the notes, and that draws his attention. He sees that it's a photocopy of the definition, and it draws it to his attention. At this time, the pandemic was in full swing, so they eventually do talk to these jurors, some in person, but most by Zoom, several months later, and about this definition. So it is important to note that at least one of the jurors had said that they were torn on complicity. And it's clear from the record they are torn on complicity. They deliberated for many, many days. All of their questions are surrounding complicity. And this is a complicity definition that's brought in. So it's the main issue of the case. That's exactly what the first juror was. The first jury was also torn on. At least one juror, many of them testified that they had seen the definition, that it was read out loud, that it was passed around in the jury room. And one juror, and this is transcript page 937 and 938, said 2 jurors changed their mind after seeing the definition. There's Marshall versus US, in which I cite, and then it's sort of that same opinion is adopted in State versus Craven through the Ohio Supreme Court. In those cases, a newspaper article was brought in, and those cases stand for, even if the let me back up a little bit. The trial court basically said that it was not the trial court's belief that the jurors were influenced enough by this definition. But those 2 cases stand for that even if the solicited responses from the jurors indicate that they were not influenced, that cannot cure this error, and that the damage was done. Now, in this case, though, there was a juror who said 2 of the jurors were influenced by the definition. That's not the only misconduct that occurred. This same juror talked to the victim's family and said that she was sorry to them. 2 other jurors saw that, and that was before they had come to their conclusion. There's also another juror misconduct in which, again, the jurors were questioned again for this, where this same juror was putting pressure on a younger juror, juror number 3, and to the extent where she was crying, she told, this is all on the record, that she felt belittled, that the other jurors, in particular, juror 8, was not being nice to her, that juror told her that she didn't have the life experience and that she was too young, and basically pressuring her to convict Mr. Yatson. She indicates very specifically that she did not want to convict him, and that juror number 8 is the one who was pressuring her to convict him. I do want to point out Wallace, because that's a supplemental authority that the court, that the state had provided. In Wallace, it was a joke that a juror made about basically wanting to get done with the deliberations and convict the defendant. And in that case, it's 8th district, so it's not binding on this court. And in that case, it was, number 1, it was caught before the conviction. Number 2, that was the only juror misconduct. And number 3, again, it was a joke. It wasn't a definition that was to the very heart of this conviction. Absolutely, it was all about complicity. The first trial, the second trial, this jury had multiple questions, again, all on complicity. So that was the main issue. And this definition was on it was a complicity definition. So it's not just a joke. It's not a minor issue. It's the main issue of the entire case. The second assignment of error deals with the cumulative error doctrine. Again, there's a lot here. Those 3 juror misconducts that I mentioned, there was also mention in transcript 918 and 921 that one juror Googled a definition of complicity. So there is a Google definition of complicity, the court provided definition of complicity, and a crossword puzzle definition of complicity, all out there. There's also the same juror who was the issue with throughout the entire time. She also says multiple times she's getting ready to go on a 2.5-month vacation. She wants to get out of there. She wants to leave. And that she basically wanted, to be done with these deliberations. That in and of itself may be equivalent to Wallace, because it's very similar, right? 2 jurors that just want to get out the trial out of their way and get done with the trial and the deliberations. But what the cumulative error doctrine is that maybe one of these in and of itself isn't enough to be error, but all of them taken together could be error. So I believe that there's enough even on this first assignment of error, but even if this court finds that there's not, certainly there's enough there with all of these errors taken into consideration that it's enough to reverse this conviction. There's also the issue of the pandemic. They deliberated for 3 days after the state of emergency was declared. All schools were closed, businesses were closed, courts were shuttered, and there's no safety protocols. There's no questioning of the jurors on whether they felt unsafe. And again, this is something else for cumulative error doctrine. Third assignment of error was that the court just erred altogether in instructing on complicity. There's no evidence to suggest that there was complicity. There's discussion of this on transcript page 965. Officer Jones, one of the officers himself, testified, and again, that's where it's transcript page 965, that there's no evidence that Mr. Yatson aided, abetted, or furthered the incident, which is exactly what complicity is. The first jury even asked, why was Mr. Yatson even arrested? Again, this is a court that allows jurors to ask questions. That's transcript page 840 of the first trial, because of the complicity issue. So the court erred just in instructing in general. There's also a sufficiency and manifest weight argument. I don't want to get into too much of those if I'm running into my rebuttal time, because I want to reserve the rest of my time.
All right. Well, you're at 10 minutes and 30 seconds, so we'll give you 4 minutes and 30 seconds for rebuttal.
Thank you, Your Honors. Lindsay Poprocki of the Lorain County Prosecutors on behalf of the Lorain County Prosecutor's Office on behalf of the state of Ohio. As Appellant's counsel has made clear, the central issue in this appeal is whether the trial court committed prejudicial error by denying Ryan Yatson's motions for mistrial and or new trial. First, it should be noted that the trial court's decision to deny Yatson's motions was within its sound discretion and may only be reversed on appeal for an abuse of that discretion. Yatson claims that the jurors in this case committed misconduct, and that allegation requires a two-step inquiry into whether such conduct actually occurred and whether such misconduct materially prejudiced Yatson's substantial rights. Yatson's claim of misconduct first relates to the dictionary definition of complicity that was brought into the jury room. After the trial court located that dictionary definition, it conducted individual inquiries of the jurors to determine what impact, if any, it may have had on their deliberations. The trial court controlled the hearings and questioned each juror separately under oath about their knowledge of the dictionary definition of complicity and what impact it had. The trial court also permitted counsel to question each juror. The testimony at the hearings established that Juror 8, in fact, brought in the dictionary definition of complicity from her crossword puzzle, and at least one other juror, Juror 9, was aware of the definition. However, all jurors, and this is noted in the state's brief, unanimously testified that they did not rely on the outside definition of complicity in their deliberations. Rather, they relied exclusively on the trial court's instructions to render their decision. Based on that testimony elicited during the hearings, the state did concede in its post-hearing supplemental brief that this particular instance of conduct constituted juror misconduct. The state, however, submitted that no material prejudice occurred as a result of this misconduct, making that the issue for appeal.
What about the three jurors who supposedly changed their position after the definition was brought in?
The state would absolutely reject that notion, and the state cites in its brief the unanimous testimony of all jurors that they did not rely on the outside definition of complicity and that they relied solely on the judge's instructions of law in making their decision. We have cited in the brief the notations in the record to that testimony, and the trial court, in rendering its decision on the motion for a new trial, rejected that notion as well. That's in his decision on the motion for new trial. And he found the jurors' testimony as to the fact that they relied solely on the instructions of law given by the court to be credible.
Thank you.
And the state would also note that although the definition of complicity was a significant issue during deliberations, the dictionary definition that was brought into the jury room, which Yatson claims was prejudicial, did not contradict, lessen, or widen the full instructions given by the trial court in this case. The trial court went to great lengths to question each juror individually. And as noted, the record makes clear that each juror unanimously stated under oath that they did not rely on that definition in making their decision. This is inconsistent with the individual polling of the jurors following the verdict, where they each expressed that the decision in this case was based solely on the evidence and the law provided by the court. This is also consistent.
Excuse me, but did the court inquire about the Google definition of complicity of each juror? Was there an inquiry on that?
I do not believe there was a separate inquiry of each individual juror about a Google definition, because I think that came up maybe in one individual voir dire of the jurors. I don't think that was a separate individual inquiry, if I'm recalling the record correctly. In either the polling of the jurors. That answers your question.
Sure, go ahead. Thank you.
Okay. And we would again note that the trial court found the testimony of the jurors to be credible, and that the trial court was in the best position to determine and evaluate the credibility of the jurors and give proper weight to their testimony. Yatson cites to several other claims of juror misconduct, including an apology that was mouthed to a victim's family. And we would submit that was not, that any comment there was one directional, very slight, brief comment to the family, and that the trial court did not abuse its discretion in denying Yatson's motion for mistrial on this claim. The state cited to a case in its brief, State v. Step, where the trial court denied a motion for mistrial on a very similar facts. And in this case, the trial court conducted immediate voir dire with juror 8 on this issue. And in that case, the trial court even did not conduct an immediate voir dire with the juror, but this case, the trial court did. So the last allegation under assignment error 1 is that emotional peer pressure was placed on juror 3 to convict. The state would note that although juror 3 spoke to the judge and counsel in chambers about certain peer pressure she was feeling and stress while deliberating, the state, upon questioning juror number 3, asked whether she could continue to deliberate, and she indicated that she was capable of doing so. And at that time, Yatson's counsel did not ask juror 3 any questions, move for a mistrial, or ask for the removal of any juror. The trial court indicated at that time that it was going to speak to the jury to ensure that continued deliberations could proceed going forward. And Yatson's counsel indicated that he agreed to this course of action. We would submit that Yatson has forfeited this argument on appeal, but in any event, he also cites no authority for his position that belittling jurors or speaking unkindly to jurors is even a form of juror misconduct. We cited a Supreme Court case that talks about the fact that deliberations in a jury room also often result in heavy-handed influencing and heightened emotions and intense feelings, and that those are part and parcel of the jury process deliberations. And even if harsh words were a cognizable form of juror misconduct, there's no evidence of prejudice as a result of the emotional peer pressure that may have been placed on juror number 3. The trial court again specifically inquired of all jurors, including juror 3, whether deliberations and any peer pressure caused them to reach their verdict. Each juror, including juror 3, indicated that the verdicts were their true verdicts and that the verdicts were not the result of coercion or peer pressure. I'd like to move to Yatson's assignments of error under number 3 and 4, which he argues that the trial court abused its discretion in providing the jury an instruction on complicity over his objection, these assignments of error are interrelated. He also argues there was insufficient evidence on complicity to support his convictions. He basically assigns as error that the complicity instruction was not supported and his convictions were not supported based on the testimony of a sole witness, Lieutenant Jones, who indicated that he didn't have any direct evidence of complicity. He takes that isolated cross-examination testimony of Lieutenant Jones out of context and argues that the complicity instruction should not have been given and that there was no direct evidence that he was involved in the offenses. I would cite the court to page 320 and 321 of the transcript and note that after being questioned on cross-examination, Lieutenant Jones indicated that he was referencing also other testimony that's been presented here. Clearly, Lieutenant Jones was also referencing other testimony and evidence that had been adduced at trial, plenty of which was elicited through his own direct testimony. That testimony and that evidence supported the trial court's jury instruction on complicity, which can only be reversed for an abuse of discretion, and included recordings of threatening phone calls made by Yatson and his friend JB to the victim the night before his house was shot up by 30 armor-piercing bullets. Yatson's hands tested positive for GSR. A vehicle that matched the description of that a caller saw driving away from the scene of the shooting was located at Yatson's residence and still warm when Yatson's residence was subsequently searched. 3 casings were found in the vehicle that were consistent with an AR-style weapon, and the casings were found behind the passenger seat. A detective subsequently loaded an AR-15 weapon with loaded magazines in Yatson's bedroom closet, which was consistent with evidence from the shooting that morning. Yatson initially claimed he did not own that gun, but claimed that, but then later claimed that he owned that gun and had only shot it into the ground that night. But later testimony from Yatson's neighbor confirmed that she did not hear any shots fired that night, but not until 6 o'clock in the morning. And the call for shots fired came into the North Ridgeville Police Department at 6:19 in the morning. Later testing by the BCI and a defense stipulation confirmed that the AR was not only operable, it was the weapon used to fire rounds recovered from the victim's household, and that the casings found in the vehicle were also fired from Yatson's weapon. DNA results from one of the magazines found with Yatson's DNA on it, evidence had Yatson's DNA on it, and no evidence was found of JB's DNA on it. And we would submit that all these findings are consistent with 2 individuals acting in concert to commit these crimes, and that there was sufficient evidence to support Yatson's convictions and to support a jury instruction on complicity.
No direct evidence that he was in the car?
I know counsel is,
My question was there any direct evidence that Mr. Yatson was in the car? I don't recall seeing that.
I would submit that the three circumstantial evidence for sure, direct evidence and circumstantial evidence are given the same weight. I would say that, so to your question about direct evidence, well, direct evidence in that he owned the AR-15, he admitted that. Let me see.
I know you talked about the telephone conversation or calls to the house, but yeah, the other side's saying, hey, this guy grabbed Mr. Yatson's gun and went over there and did this, and he wasn't there. He didn't have anything to do with it. I mean, that's the defense, right?
That's the defense.
Yeah.
We dispute
Okay, well,
that by DNA evidence and
a lot of that stuff would be consistent with a gun owner, though, wouldn't it be? A gun owner who goes out and does target practice in the backyard is going to have, gunshot residue on their hands. They're going to have a weapon in their house. They're going to, a lot of that would be consistent with what the defense says. That's why my only question really was towards it. Was this a totally circumstantial case, or was there any direct evidence linking him? Sounds like it's all circumstantial to me.
It's somewhat circumstantial, but I would say that direct and circumstantial evidence have the same weight. And
yeah, I understand.
Okay.
All right, and I'm sorry, but my question put you over the time. Did you want to just say a few words to wrap up?
I would just go to maybe the manifest weight argument and indicate again that, as always, the credibility and weight of the evidence is for the trier of fact, and that basically the manifest weight argument in this case reiterates essentially the sufficiency argument. And we would just note that this is not a case where the jury clearly lost its way, and we would ask for the convictions to be affirmed.
All right, thank you. Attorney Bremke, I'm going to give you 5 minutes, an extra 30 seconds, since I went over with the state's argument there. So you'll have 5 minutes. Go ahead.
Okay. Judge Callahan, do you have a question?
I'm going to let you get started. Okay. I think I have two, but you know what? You may address them, so I don't want to take up your time.
Okay. So the state brings up a few things. One, that the definition doesn't expand the definition of complicity. And I feel like compelled that I have to read to you what the juror's testimony was. And it said, we got that definition, I guess, on the dictionary version. It helped two of those jurors come to their own personal conclusion. That's transcript 937 through 938. I'm also going to note that on two separate occasions, this jury asked for a different definition of complicity and were denied by the trial court. My whole argument is, why do we go through this entire jury instruction process? We vetted out, we always, there's lengthy discussions between all the parties, also that we can have the correct definition, OJER, everything. And then we allow a crossword puzzle dictionary definition to be the controlling definition. I can't believe that the state would argue something that it would not expand the definition or change the definition, specifically when a juror mentions that it did, that definition had changed the definition, and that the jury was denied twice by all of the parties to have a different definition. It cannot be said that that's not prejudicial. Reading the transcript, it's explicit that they changed the minds of jurors. I also want to note that by the time this was post-conviction, so by the time the jurors were questioned because of the COVID-19 pandemic, it was many months later. So this inquiry in their minds were not very fresh to it. They were being questioned, I believe, in June and July, and the conviction was in early March of 2020. So it was many months later. This was, different than a lot of the other cases. This is between conviction and sentencing. Even that Wallace case, there's a way that the court can inquiry and remedy it. In this case, that's not the case because he's already convicted at that point. This is a case, again, where Mr. Yatson's counsel does a very good job at objecting even to the jury pressure. He files multiple motions to dismiss. There's motioning back and forth. There's things on the record. Everything was objected to on multiple occasions and briefed out in the trial court. There's also, again, 3 separate times when jurors are questioned as to whether as to jury misconduct. So the cumulative error doctrine is not something that I think is commonly ruled on, but is a very good argument in this case. There are, the general public could not look at this case and say it passes the smell test, that Mr. Yatson was afforded a fair trial. The fact that jurors had to be questioned on 3 separate times about misconduct in the deliberations is something that I don't know that I've ever seen or this court's ever seen. It's absolutely right for the cumulative error doctrine, and this conviction needs to be overturned. Any questions? Judge Callahan, I answered your question. So again, I would ask that you overturn the conviction. There's a lot here and a lot in the transcripts, but I think that when this court reviews it, they will find that there's just a lot of error, particularly with juror misconduct, but there's error all around, and that the conviction needs to be overturned. Thank you, Your Honors.
All right, thank you both for your arguments, and on behalf of Judge Callahan, Judge Hensel, we want to thank you for appearing by Zoom once again here. It's good to see both of you again. The court will take the matter under advisement, issue a decision in due course. Clerk of Courts will mail each of you a copy of the decision on the day it's released. And as you both know, the opinions are posted on the Supreme Court of Ohio's website. Those were the 2 arguments we had via Zoom for today. So we'll be adjourned until April 12th.